Hello and welcome to this latest Becoming a Better Director bite-sized webinar from Companies House. This is the third of 4 short webinars to help you to understand the responsibilities of becoming a company director. We only aim to keep you around half an hour, about half an hour. So I'm going to hand over straight away to Flynn and Jenny from the ICO for today's presentation. So hello both.
Hello. Hello everyone, and welcome to Data Protection, what you need to know and where to start. Firstly, I'd like to thank Gary and Companies House for working with us and providing the opportunity to speak with you today. We're from the Information Commissioner's Office, the UK's regulator for data protection legislation. As Gary touched upon, our role is to uphold information rights in the public interest. A key part of our work is supporting small businesses in achieving compliance through practical advice, which you'll be able to find on our SME web hub. The web hub has top tips and simple tools designed to help small and medium businesses get to grips with data protection. It has everything you need to get started, check how you're doing, and improve your compliance. We also have friendly and knowledgeable staff on our helpline and live chat who can guide you if you get stuck. The helpline number is at the bottom of this slide here, and you'll also see a link to our SME web hub. So my name is Flynn. I've been a case officer in our business advice department for about 2 years now. If you have contacted us for advice in that time, there is a good chance I may have helped you.
Hi, I'm Jenny, and I'm also a case officer in the business advice team. I've been with the ICO since 2017, which is before GDPR came in. So in terms of outline, we're going to start the presentation by explaining what data protection does and doesn't cover. We'll help you ask the right questions to understand your processes. We'll discuss trusting your data protection instincts and how to be clear and transparent with your customers. We'll explain how to stay on top of the information you hold, keeping things simple and staying organised. We'll talk you through what to do when things don't go to plan and where to go for help. And we'll finish by explaining our registration process. As Gary explained earlier, we have our colleagues Charisse and Sophie answering your questions as we go through the presentation. So if you think of a question as we're talking, just pop it into the question box and they'll try to answer as many as they can.
So our first tip is know what data protection covers and what it doesn't. There is a common misconception that data protection prevents businesses doing many different day-to-day activities, but this is simply not the case. Fundamentally, data protection is a how-to rather than a don't do. For example, some questions we're often asked are, does data protection stop you sharing information with other business partners? Absolutely not. Allowing responsible data sharing is a key part of data protection law. Or maybe, does data protection stop people working from home? Not at all. Providing that the right security measures are in place and your staff are trained on how to handle personal data outside the office.
So data protection law is all about personal data. Personal data is any information that identifies and relates to a living individual. As part of running your business, you're likely to handle people's personal data, and an example might be an employee's name and address. Information about your business, though, is likely to be business data and therefore not covered by data protection law. An example of this is your company accounts. To comply with the law, you'll need to identify which lawful basis fits with what you intend to do with personal data. There are 6 lawful bases, namely consent, contract, public task, legal obligation, vital interest, and legitimate interest. Identifying one of these reasons for using the data helps you understand why you're doing what you're doing. And although consent is one of the lawful bases, it's not always the right one, so do choose carefully. So then, if an online clothes retailer is sending an order, they won't need the customer's specific consent to pass their delivery address to a courier service. This is because the data sharing is needed to make sure that the clothes are delivered and the contract is fulfilled, making contract the most appropriate lawful basis. There's more information about the lawful basis as well as an interactive tool to help you on our website.
So in a nutshell, really, data protection is about protecting and upholding people's rights, but this doesn't encroach on your ability to carry out your business functions or have processes with a minimal privacy impact. In fact, it actually enables you to practice good business and comes with many benefits that we hope will become clear throughout the rest of this webinar. So our next tip is ask the right questions and think about what you want to do. To help better equip you to think about data protection in the right way, we have a set of questions we recommend you ask or think about. This could be when starting a new project, creating procedures, handling a request, or maybe entering into a data sharing agreement. I'll talk you through key ideas that pop up throughout data protection law and questions that I commonly rely upon while giving guidance on the phones. Jenny is going to come in after each question with an example based on a fictional business to help you with the practical application. So the first question is, what is the purpose for your processing? Or in other words, why are you even doing it? This may seem obvious, but you may have experienced how easy it is to get bogged down in the details. This is why it's important to simplify and go back to the start of why you're doing what you're doing and keep that clearly in your mind.
For example, a clear purpose might look like the following. So Manufacture for You, a manufacturing business, needs to monitor employees working with heavy machinery to check staff are operating in line with health and safety policies and reduce the risk of potential harm to them. The lawful basis here is likely to be legal obligation.
So the second question to ask is then, what personal data is necessary to achieve your purpose? So identify exactly what you need and be able to explain why you need it, linking it clearly to the purpose you have already outlined. A good exercise here is to separate the absolute essential information from the nice to have, because you should always approach any processing by using as little personal information as possible.
So Manufacture for You identifies that they need information of any health and safety incidents and an account of staff practices for this processing to work. They consider whether they should have a health and safety rep present on the factory floor, or if it would be useful to install internal CCTV to monitor staff activities while operating the machinery.
The third question is to ask if this is a proportionate amount of personal data to collect in order to achieve your purpose. So is the amount of personal data you would like to process, is it a reasonable amount to use in order to achieve that purpose? This is where your earlier distinction between essential data and data which is nice to have will help you. You'll need to consider whether collecting that nice to have personal information is necessary and proportionate. If it's not, you should not be collecting it.
Manufacture for You considers what is proportionate when installing CCTV. They recognise this would capture a lot of information about their staff, which isn't relevant to their health and safety purpose. On balance, they decide using CCTV to monitor behaviour in this way is too privacy intrusive and risks damaging their good relationship with staff. So they rule out installing the cameras.
So then the fourth question to ask then, well, is to think about whether there are any less privacy intrusive alternatives to achieve your purpose. Consider these with a pro and con approach. Are there other options that would be more practical to implement, or are there alternatives that have less privacy risks?
So this left our Manufacture for You thinking about hiring a health and safety rep to be on site at all times. However, they realised an alternative could be to use team leaders who'd be making observations as part of their usual role. They could report back to the manager, who could compile a weekly report from the observations on whether health and safety policies were being adhered to.
So the final and possibly most important question is, what impact or effect is there on the people whose data you're using? This should always be in your thought process, as it's important to regularly review the effect on the people involved to ensure minimal privacy risk. Here, think about it from their point of view. Is it too invasive? Are they likely to object, and why? Is there any detriment to them because of this processing, or is this within their reasonable expectations? Questions like these will help you identify practices to mitigate any concerns and shape your processing.
So Manufacture for You were able to justify that it would be within their employees' reasonable expectations that team leaders would monitor them to ensure health and safety policies were being followed. They produced a privacy notice that explained this new process and informed all workers of this. The business could justify that their management team were able to limit the data captured to only what was relevant and that their processing was transparent.
So I hope, as you can see, that using these questions will help ensure your data handling practices are fair, proportionate, and necessary.
Our next piece of advice is to trust your instincts. So when processing personal data, if you use your common sense, you won't go far wrong. Start by putting yourself in other people's shoes and consider, if it was my data, how would I want it to be handled? How would I feel if my data was disclosed inappropriately to someone I knew? I imagine you'd want a level of control over how organisations are processing your personal information, and this is something that data protection law affords through individual rights. It includes the right to have your data deleted, the right to stop processing in certain circumstances, and the right to obtain a copy of the data organisations hold about you. That's often referred to as making a subject access request, or a SAR.
So to give you an example of considering what's reasonable, let's say you're processing a subject access request and you have information that references other people, otherwise known as third parties. If your instincts tell you this data shouldn't be disclosed, listen to them. Why do you think this would be unreasonable to share? Will the third party expect their data to be disclosed? Document your reasoning and consider if it is enough to be a compelling justification for withholding the personal data. There is no legal trickery here. Deciding whether or not to disclose can be common sense and is very context specific, so you will be in the best position to decide to redact or not. But if you're ever not sure, just give us a call because we're here to help.
And this works the other way too. If you're looking at basic or straightforward information and your instincts are telling you that there's no issue in disclosing the data, you might not need to redact it. Maybe it's information the requester already knows about, for example, minutes of a meeting they've already attended. And if that's the case, it doesn't make sense to redact information they're already aware of.
In a different scenario, it may be appropriate to look at the exemptions in data protection law. Exemptions can change your legal obligations. This can mean that you can share personal data in certain circumstances where you ordinarily wouldn't be able to, or that you're able to withhold data for specified reasons. So, where your instincts are telling you to share information, but maybe not tell the person, let's say if the police were to ask you for a copy of your CCTV footage, there's an exemption that will allow you to share this with them discreetly. Or maybe you're making difficult decisions about redundancies and don't want to disclose personal data which may affect any future negotiations. Data protection law will enable you to withhold this for an appropriate period of time.
But in all cases, when relying on an exemption, you need to be able to justify it if challenged. You should keep an internal record of any decisions you make. This will help you show your reasoning if you're ever challenged and can help reduce the time you spend dealing with requests or complaints in the long run. Trust your instincts and use the guidance in our web hub. If you feel unsure or concerned, you can always call us for advice.
So now let's put your data protection instincts to the test. We've created a little scenario here, which is on your screen now. It's not meant to catch you out at all, just spend some time considering your answer based on your immediate instincts. Once Jenny has read the scenario, a poll will pop up on your screen for you to submit your answer. So in the following example, what would you do?
Manufacture for You has received a request from Sam, an employee, which states, I want all of my data in the most recent manager report to be deleted as per my legal right to be forgotten. This manager report records how Sam has breached health and safety procedures. This will be crucial evidence during planned disciplinary action. Manufacture for You wants to keep the information for the upcoming hearing, but doesn't want to undermine Sam's individual rights. So putting yourself in their situation, consider if you would A, delete the data, or B, keep the data.
So we'll just give you a moment to submit your answer. The option should be on your screen now, whether to be A or B. There we are. So I think we're going to close the poll now. I think we've given that enough time. Well, it looks like we may be having a few difficulties with the responses on the poll, so I think we'll just move on. But it's important to note with this that the right to erasure, often referred to as the right to be forgotten, it is not an absolute right. So in this example, the correct answer would be B, keep the data, as it is reasonable for manufacture for you to retain the data relating to Sam's breach in health and safety. On balance, the business here has a compelling justification to keep this data in order to ensure legal obligations are complied with. Be aware though, this isn't a blanket exemption. If there's other information relating to Sam contained within the report and there's no other relevant exemption, it's likely they'll need to delete this data as per the request.
Our next tip is to be transparent. People typically have a right to know what you're doing with their data, and it's usually easiest to let them know this through a privacy notice on your website or in your welcome pack. Proactively telling people what you do with personal data in a clear and transparent way will increase people's confidence in your collection and use of their information. Think about how your audience interacts with you and make your privacy information available to them in a way that will be most accessible to them. Letting them know what personal data you need, why you need it, who you'll share it with, and how long you'll keep their information will encourage your customers to trust you and enhance your reputation. If you're unsure of how to write a privacy notice, our template will help you, and this is available in our web hub, again linked at the bottom of this slide.
So our next tip would be, don't keep personal data longer than you need to. There are so many benefits to only keeping the information you need. The less personal data you have, the less you'll have to sort through if someone submits a SAR to you. The less data will be at risk of a personal data breach, and you'll also have lower storage costs. We mentioned earlier how having good data protection practices can save you time and money, and retention schedules are a great example of how. Now, data protection doesn't set specific retention periods. You can keep the personal data you need for as long as it is necessary to do so, but keep in mind you shouldn't hold on to personal data just in case. So first, identify why you're holding the personal data. It might be that you need to comply with legislation relevant for your sector or for insurance purposes. If that's the case, then a specific retention period may already be set out for you. If you're only retaining personal data in relation to the service you're providing, you will need to set your own retention periods. You might want to consider how long someone may use your service, for instance. But again, you'll need to document your reasons for the retention period you have decided on. This should be regularly reviewed, and any personal information you no longer need should be securely deleted.
Remaining organised is a key tip that will help you deal with requests quickly, action business processes efficiently, and make sure you don't trip up with data protection. But how do you achieve this? So firstly, know what information you hold, where it's stored, and what you do with it. This is an integral element of being accountable for data protection. When you organise data consistently, store it safely, and in a way that enables you to retrieve it quickly, you'll save yourself time in the long run, especially if you make sure that your staff are aware of and have had adequate training on data protection. For example, if your systems are organised and structured, it will be easier to locate and access information efficiently. Also think about whether you need to hold all data as personal data. Is it worth fully anonymising it by removing the name or other identifiers? This is useful if you're keeping information for general business statistics only, and it can help reduce the risk of personal data being mishandled or misused. Holding on to information you don't need creates more issues for you. It makes you less organised, slower to act, and increases your security risks.
The second point would be methodical. If you approach data protection methodically, you'll find it goes much more smoothly for you. Taking a step-by-step approach from the start will save you time in the long run, and as your business grows, your processing will also grow with it. So that is why it's important to put clear, structured processes in place from the very start. So let's consider subject access requests again. Adopting a methodical approach when dealing with a SAR will make it far easier. This can be through following a step-by-step process that breaks up the different actions, such as identifying the relevant personal data and then considering any third-party redactions or exemptions. Don't try to do everything at once. This will only slow you down and take up more of your time. A methodical approach should be taken to all aspects of data protection.
The next thing to consider is staying on top of your online security. There are some very simple steps you can take to make your information less vulnerable to cyber attacks. The first thing to do is set user accounts with strong passwords and configure all your devices to lock when left for a certain period. Then consider your router. Change the password to something stronger than the default on this as well. Next, you should get some antivirus software and ensure it's kept up to date. This isn't an exhaustive list, so visit our web hub to see our guidance on practical ways to keep your IT systems safe and secure.
Another thing to keep in mind is don't panic if things don't go to plan. When things do go wrong, or maybe you make a mistake, it is important to respond quickly, consider the risks, and learn something from it. If something goes wrong and you have a personal data breach, your top priority should be to contain and mitigate the breach. Take action to reduce the risk of harm to the affected people. A personal data breach must be reported to the ICO if it puts people at risk. Risk would be where there's some detriment to people's life, which is above minor stress or inconvenience. You have up to 72 hours from becoming aware of a breach to consider the level of risk and report it to us if required. So use this time to take any action to contain or reduce that risk. If you are able to reduce or mitigate risk to the people affected, you might not need to report the breach at all. So for example, if you were to accidentally send an email containing sensitive personal data to the wrong email address, you should try to recall the email. If this doesn't work, consider contacting the recipient and asking them to delete the email without opening it. If you're satisfied that they have done this, you wouldn't need to report the breach. Your quick action has contained the situation and reduced the risk. But make sure you keep a record of the data breach that details what happened, as well as the actions taken, and share lessons learned to avoid it happening again.
Of course, every issue is different and has different levels of consequence. However, it's key to always act quickly to help stop what might be a small issue growing into a larger problem for your business. When things do go wrong, it might not always be because of a personal data breach. So if someone complains about the way you've used their personal data, be prepared to be open about what's happened and why. Acknowledge if something has gone wrong and let them know how you'll put it right. Take a note of lessons learned and how you can adapt your procedures for future. Consider whether further staff training or support is needed.
Now, where to go to help would be our next tip. As I mentioned at the start of this webinar, we have a web hub that's specifically written for small and medium enterprises, including sole traders, small businesses, clubs and charities. The guidance is in short, easy to read sections and will tell you what you need to know and set you off on your data protection journey. If you need further help with any data protection issues, we also have live service teams to answer your questions. Our services are confidential, and our priority with small businesses like yours is to provide advice and guidance that enables you to build and grow your business. While we do have the power to issue fines or penalties, such fines are commonly reserved for only the most serious infringements. We much prefer to help and educate businesses instead.
So now on to registration with us. The work of the ICO is partially funded through the data protection fee, and most businesses need to pay this unless they meet certain exemptions. For most small businesses, this is £35 or £55 a year if you pay by direct debit, as there's a £5 reduction for using this method. Your business will be added to a public register of fee payers, which shows your customers and business contacts that you take your data protection obligations seriously. You can find out if you're legally required to pay the fee by using the self-assessment tool on our website. You can also get further information from our digital assistant on the data protection fee web pages.
So that's all from us. Thank you very much for listening, and thank you for joining us today. If we did not manage to answer your question, please visit our website or get in touch with us. If you'd like to receive regular updates, you can follow our social media accounts and sign up to our e-newsletter. Thank you all very much for listening.
That was brilliant. Thanks both. Sorry about the poll. We had a bit of a technical issue there. You covered a lot of ground, and I think it'll be really useful to everyone watching today. Now, just to finish off, we've only got a couple of minutes. I'll mention a couple of online services that we offer here at Companies House. So recently we've launched a new free online learning tool for directors, which takes you through the responsibilities and annual filings, and the link is in the handout. The tool takes you through your responsibilities as a director and shows you how to make your annual filings with links to the relevant parts of the Companies House website, and it also incorporates our very useful how-to videos. Just a quick mention of email updates. Now, by signing up to our email update service, we will inform you of any changes happening in the world of Companies House, so you know what's happening and when, and this is separate to the email reminder service, which I'll mention in a moment. So basically, we'll send you an email with any new development or events that we are holding, and usually this goes out every 2 weeks. We also have a Director's Toolkit. The Director's Toolkit takes you through your responsibilities as a company director, provides guidance on how to file your documents, and make sure you comply with regulations. I mentioned email reminders, so if you do own a company, please sign up for our email reminder service. Again, this is a free service that allows us to remind you when your important documents are due, so you don't miss any of those deadlines. And you can have up to 4 email addresses, so if someone's away, one of the others should get a notice to say those documents are due. So that is virtually on time. Thank you very much for joining us. Thank you again to Flynn and Jenny for presenting today, and the people in the background answering the questions. And most of all, thank you for joining us. And if you can sign up to next week's one, we'll see you then. So goodbye.